Meeting to order, and Dr. Hembry, would you do the invocation for us?
Please bow our heads. Dear Heavenly Father, please watch over this body as they come together to do the will of the Cherokee people. Please watch over the staff and employees who've come here to do the same. As we begin this Lenten season, Lord, we know there are troops that are in harm's way. Let's please pray for their safe and speedy return. And please watch over the principal people of the Cherokee. In the name of the Father, Son, Holy Spirit. Amen.
Amen. Thank you, Tom. Roll call.
Meredith Fraley.
Here.
Buell England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzer.
Here.
Julia Coates.
Here.
Bradley Cobb. Joe Crittenden.
Here.
Jody Fishinghop. Here. Janelle Fulbright. Don Garvin. Chuck Hoskin Jr.
Here.
Hannah Gloria Jordan.
Present.
Curtis Snell.
Here.
Krista. David Thornton. Kara Cowan Watts.
Honey.
We do have a quorum.
We have a quorum. Next order of business is approval of the minutes. Unless there's objection, I'd ask that we make a motion to table these in total. Approve these in toto.
Second.
Any discussion? All in favor signify by saying aye.
Aye.
All opposed, same sign. Minutes stand approved as written. First report is Sharon Wright, Marshal Service. Afternoon, Sharon.
How are you?
Fine, I think.
Well, I know you have my report in your packet, and then announcements since the report. BIA gave us a car yesterday. We're so very happy. So we're waiting on the paperwork on that, and then we'll have another car online. We also have the Polar Plunge this weekend. We hope all of you come out to Arrowhead Resort where the Polar Plunge is for Special Olympics. And besides that, I'm going to hit you up all for monies. Hey. So I brought my sponsorship form, and I'll even wait around and let you think about that. And then we went to Washington County, and I know Dr. Cobb had been pushing that pretty hard. We met with the sheriff, and he was going to go to his Board of Commissioners Monday, and hopefully we will have a cross deputation with him and do a photo and those kinds of things up there Wednesday. So if you want to be a part of that, they'll be doing that Wednesday if the county commissioners okay the cross step, but it looks like it will be done this Monday. So we're excited about that. We haven't had one with them since Wilma was chief, so we're real excited about that. Any questions on?
Questions or comments? Yes, Ms. Fishinghop.
Sharon, can you tell us something about running over the guy in Adair County, or bumping him, or whatever you want to call it?
Without being as funny as I was with you before. There was an incident in Adair County where an individual was drunk, high on paint and other things. He had a knife. He said he had a gun. He was threatening to kill people in the area. He was threatening to... he had people on 911 telling him he was going to come down there and kill them, kill other officers. He was just doing a lot of threats. Part of that hasn't went in front of the board, but the investigation is done on that. In the end, to control him, and I think he dropped the knife and he had a ball when he busted that. Control him, one of the officers used a vehicle and kept getting closer and closer into the situation. He actually thought it was a vehicle that the officers that were standing was not allowing to go through the roadway. So he was threatening all the officers, and he was like, So they end up bumping him with the vehicle. He's in the hospital, and a lot of that had to do with he was so inebriated that when he fell backwards, he did not do anything to catch himself. So he is still in the hospital from that injury. Now the report and some of the investigation into that, NTOA says that that is a viable use, less lethal use of force because it was a controlled type of maneuver. And that's basically that incident there. But he was not only on alcohol, but he had been doing paint and different things like that, which made him pretty violent and non-controllable.
Okay. Sharon, I've asked this before, and I don't think I've got an answer. I realize he was messed up, but at what point did we go from, like I said, shooting him with the taser, masoning, pepper spray, beanbag shots, to he's there with a knife threatening me, or we're going to run him over? I mean, why didn't we go to something else before we jumped from A to D?
Because we don't have most of those items that you said. We do have OC spray, but to use that, you would have had to been in closer contact than we were with him, and him having a knife and alleging to have a gun in his back pocket. You didn't want to get that close, so we don't have the other less lethal instruments that you named off.
Okay. The guy that done this is the same one that was involved in the shooting in Adair County, and I realize that. And here's my question: is Adair County perhaps taking advantage of us? Because, okay, let me back up. What is your all's role when you go out where the county calls on you? Maybe I need to get that clear first.
Well, the first incident you're talking about is different in the fact that they actually called for a team response. And we have one of the very few SOT teams in this area. So they ask for an SOT team. Different kind of call. We do that for a lot of the counties because a lot of the counties do not have an SOT. This one was actually just a call for assistance. Adair County's manpower being what it is, I understand that their budget's even quite a bit narrower than ours, so they don't have a lot of men out there. So they request backup, and when they request backup, whatever officer is close will come to a scene. Not just the Marshal Service, but I mean if OHP had been in the area, you would have seen them there. We just happen to have officers out on that same shift that works in that area. Then the both of their officers and our officers, they didn't have a supervisor out, and they called one. The guy who used the truck, he was the supervisor. And he came toward the end of that incident. But yes, anytime they call and need assistance, it's not just us, it would be anybody, but we happen to be out in that area because in that district we try to have someone out in each district on each shift.
No, what I'm trying to figure out is, if we're back up, why didn't Adair County run them over?
That I don't know, other
does the
than,
family have a right to sue Adair County or us or the guy individually? Maybe that's a question for the Attorney General.
well, they have the right to, I mean, I don't know if they have the right to, but you can sue anybody you want to sue. And you can sue every single officer that's on the scene, and that has happened. We did take statements so that some of that is covered because his family was there, and they agreed that the best course of action was taken. So taking their statement at the time gives them less recourse to then sue because they agreed at the time this was the best recourse to take and that they were happy with the results that it ended. But anybody can sue anybody, so they could sue us, Adair County, any other officers there in their line of work, and individually. So, and that happens at different times.
Okay, that's all.
Ms. Gloria Jordan?
Sharon, we've got a cooperative agreement with, cross-deputizing agreement with Adair County, is that correct? Well, what does that agreement say as far as liability?
That the liability of training and all of those things stays with each agency. So if I went to their call, I would be saying that the training of that officer to do the correct thing lies with the training agency. Adair County is liable for their conduct, we're liable for our conduct.
So if we're out as a support role for Adair County and it results in a death, then there is a way then that those individuals can sue, the families could sue us, sue the nation. Have we given some, have we waived some immunity in those agreements?
No. Diane can speak better to the cross debt because she's the author of it, but we don't waive our sovereign.
What is it, maybe I need to direct this towards Diane then.
Yeah.
What does the agreement say pertaining to liability?
It just ensures that whatever insurance or protection you have for your government carries over into your actions in responding to the other agency. So what the agreement does is just make sure that you can respond and act as a police officer. You still are acting under the authority and limitations of your agency, but you're acting under the authorization of the jurisdiction in which the crime happened. Our marshals are covered under the Federal Tort Claims Act, and we've had cases, you know, when you have police force and police officers, you're going to get sued. You're going to have those cases, and they usually go through the U.S. Attorney's Office, and we assist the U.S. Attorney's Office in defending those claims, and we've always been successful.
Well, and this is probably a question for both of you. Is our mission, when we are called upon to provide support to another county government, is it as a backup for the most part?
Sharon's probably better to answer that than me.
We should be secondary most of the time, but there are times that they call us saying, we have no other officer out, can you take the call? And in that situation, yes, we're responding as a primary agent, and we're responding as their primary agent because it's under a cross debt.
But if we arrive on the scene and they're already there, then our mission, our goal, objective is to act as backup.
That's correct. The thing that happens on the scene most often, I will tell you that because we are trained at a higher level, they will ask us, what do you think we should do here? They will actually ask us for guidance in a situation that we're at.
But we don't assume charge of that operation.
We have never just came in and said, I'm in charge because I'm here. No. The only condition to that is if you ask for our SOT team, when we arrive and tell you what our plan of action is, you can say, okay, or if you try to say, no, I don't want you to do this, I want you to do this way, then we will return it back to you and say, as a team, this is how we do things. If you want to take it, you take it. Otherwise, we don't do that. And we've done that with agencies and actually backed out of the situation because as that team, the team leader has to give guidance.
Well, and I ask these questions with all due respect to your agency because I know that we shouldn't try to quarterback after the incident. But it seems like what I'm seeing in Adair County is that we have an abnormal amount of activity going on, that our officers are the ones that took the shot, used the vehicle, used some other means of restraint, and we don't see local law enforcement stepping up to the plate, and it's their plate. And they're not the ones stepping up there to take charge. And I wonder, I think one of the questions is, are we being taken advantage of? And I think in just looking at some of the situations, it appears outwardly that yes, maybe they are taking advantage of us and that they need to be the lead and we need to be the backup. We don't always need to be the first one that goes through the door. And if we run over someone, I hope they've been run over twice, because I'd like for us to be the second one. If they've been shot, I hope we're the second shot, because I think they need to be in charge of their local problems. I think that our mission, when we originally set up law enforcement, was to offer support, to be backup. And I think we're getting beyond that. And I also think that because of that, we may be getting ourselves into a liability area.
Well, one of the selling points for cross-deputation is that we do train to a certain standard. We train to the federal standard. So we do the in-service hours and all of those that are required. That puts us at the ability to sort of work through a situation a little more trained than anyone else on that scene. So do they rely on us? Yes, they do. I never think of it as taking advantage of us, because one of our selling points, we don't give them money, we don't have the equipment to give them equipment. Our selling point to cross with us so that they will sometimes answer a call on Indian country and we will work together seamlessly across the way is because we are trained to us. We do the training that's required. And they do look at us, and they do ask for us to go probably a step further than they would, because they're unsure of where that step should be.
But we're kind of enabling them in not getting the proper training themselves.
And we are working on even that facet of it. I mean, we have got instructors to try to help go to the agencies and start training. And as of this fiscal year, we have started asking them if they want to do special tactics training with our SOT so that they can actually react instead of standing on the sideway and say, do what you need to do. They can actually react with us. They've not had that before, and I haven't got those MOUs and MOAs in place, but that is a way to bring that to the table for them too.
And again, I don't mean disrespect to your group, but I think there's going to come a point when the local entities need to step up to the plate and do their job instead of us stepping in front of them to do their job. And that's all I have.
Mr. Buzzard, then Mr. Thornton, and Mr. Snell.
Sharon, just a couple of questions, and I talked to you about, would you check to see if we have process in a deputization with the Fairland Department?
We will.
And then the other, I was just wondering, how much difference is the salaries, or about how much difference is the salaries between our marshals and then other police departments? And I don't know what other police department you use to judge that by. Is
Well,
there a
I
big
know-
difference in salaries?
I know that our salaries have drifted way below the norm. Tahlequah City has taken some of our officers just because their starting pay is higher than what my officer is getting 2 years into the job. So I've lost officers about the 2-year limit. If you look at the casino security that's armed, they're getting paid about $2.40 more than my beginning officers. So that puts us, we're at a $13 entry level. They're at a 15-something entry level. If you look at the law, we're supposed to pay the same standard as BIA pays their officers for the same job. And I am working right now to raise that pay. I am understaffed because they've left to other jobs right now. So until I can get their pay adjusted to what is norm, I'm not going to put out another panel until I can get that justified. And if it brings their pay up higher, I may have to reduce the level of staff, and that's why I'm doing it now, because I've already got a lower level of staff.
Okay, and I've heard the same thing, that we keep them for a year or two, then they get better paying job, and that's the reason we go. And it just aggravates me that we put all the training into these guys, and they leave us after a year or two, and it goes with other departments too. You know, and I appreciate, and I'm sure they would too, that you look into the pay scale and see if we can't, come up with a better pay scale than what we have.
Well, if we kept at capacity, where we were,
Yeah.
because the budget hasn't, it's been stagnant for a while. So if we stayed at that capacity, I couldn't do it. Since we're already at a lower level,
Yes.
we'll just try to bring that up, keep them, that way your quality of person is higher that you hire in, and then maybe we'll retain them better.
Because I know you put a lot of training into it. Okay, thank you. Thank you, Madam Chair.
Thornton?
Sharon, when the Marshal Service come around here in the past 8 years, 9 years, I think we've become more effective, you know, and what we were there for was to protect our trust land and our restricted land and to support our Cherokee Nation citizens. And then we come out and we got cross-deputized. And we did that because we couldn't do anything on public property or private property, and the sheriff's office or the police, local police, law enforcement couldn't do anything on restricted land or land in trust. As far as who's in charge, from my knowledge of what I've known in the past, if you're on public property or you're on private property, county sheriff is the first one. Now that's the way I've always been taught and learned. And it goes down from there. You know, state law enforcement and local law enforcement. But what I was interested in, did this person that you all was trying to incarcerate, arrest, or whatever, did he have a weapon on him?
He had a knife on him, and into that a little later he had a bottle that he had broken on him. Even though he said he had a weapon in his back pocket, I think at the time they put him in the ambulance, they did not find a weapon, not another one in his back pocket. But he had said that, and he also is recorded saying that on 911 because he had them on the phone stating that he had a weapon in his back area and that he was going to use it.
His weapon, did he ever have it in his hand?
The knife he did, yes.
Okay. To be 18 foot away from you, how long does it take me to kill you with a knife?
It's actually it's actually just a few seconds.
3 seconds is what it is. And you know, our deputies, I don't care if they're challenged with a person with a knife or with a weapon, what you're trained to do and plead is kill them. You stop them.
And they were actually justified to
Right.
have shot the individual.
Right.
And that's what NTOA came back in the investigation to say.
And then you go to court after that. But your main objective and our deputies, our marshals' main objective is to go home tonight from our job and to be with our family. And if you hadn't taken law and taken force, well then it looks like to me you'd be in trouble as far as I'm concerned, you know, being a counselor. And when you're called out to support another law enforcement agency, you have to go. That's the way I look at it, the way I've been trained. So, you know, I don't know a lot about this, but what I've heard, it sounds like you did what was right. And I appreciate that.
Mr. Snell?
Sharon, would you bring us up to date on the hunting issues?
They're still hunting. Hey. All of them's been getting given the tribal ones in each sub office. The officers know that they're supposed to watch the ingress and egress. We do not have officer assigned to that. We've never had a budget approved for that. So everybody just does it the best they can. One of the steps we have discussed taking, and I've talked to one of my lieutenants, is to go ahead and see if we could get a cross step with the state, because we don't have a compact. If we could get them to cross step with us, that would maybe keep them from ticketing people once they leave the Cherokee lands. So we're going to look at trying to do that, and that will help us, I think. As far as watching the lands, we've been working with Angie and her group, Natural Resources Group, to try to make sure that what signage is there gets put up, as best that they can get up, and that way people have a way to read before entering that they need to obey the laws of the Cherokee. I think that we probably don't have as much signage available to be put up right now as needs to be, but they are working on that, and we are still watching those bigger parcels of trust land so that we can watch the ingress and egress and check people on those bigger parcels.
Okay, thank you.
Ms. Fishinghoff?
Sharon, was that, you told me about Rocky Mount, was that on restricted land?
Actually, the call said it was, and a couple of the people from that community said they knew it was. We've done a real estate check, and I don't believe that it is.
It wasn't?
I don't think so. They've not got the answer back, but the informal answer from Realty was it was not restricted. But the original call was that it was restricted.
And you said he's still around?
Yes.
How long ago did that happen, Sharon? I'm trying to figure out my mind.
I'm trying to think of the date, but it's been
It's been a couple of weeks.
just right at, I think, 2 weeks. Because they just finished the internal report and it goes in front of the board next week. So,
When you can you get copies for me, please, of the report? Thank you.
Any other questions? As Dr. Cobb?
You may have touched on this before I arrived. I apologize. How are we doing in Washington
Shortly
County?
after 1.
we met with the sheriff. He's going to meet with his board of commissioners Monday. He believes that he should be able to get one. And then if it's signed Monday, he wants to do the photo thing Wednesday at 10 a.m. up at his place. So.
Any others? Sharon, Mays County came by and visited with me this week, and they really appreciated your help on those 2 shootings we had in Mays County. Those were kind of treacherous shootings, and they were just a week apart.
Yes.
So they appreciated that, like your bulletproof vest, the kind that you have, they don't have, and I guess the kind you have withstand those AR rifles.
The SOT vest, and they helped with the SOT event. They are a higher quality of vest.
Yeah. Now they're ones. Thanks, Sharon.
Well, whatever we can do.
Thanks very much.
You're welcome.
Ms. Hammonds?
I can't use it. They have their money special.
I just wanted to say thank you because Sharon and her folks did a really great job in Foyle, I believe, or Sequoia, on a drug test. And our Sheriff Scott Walton, who's a tribal citizen, was very pleased with their work and appreciated their backup and assistance and the SWAT team going in first. Thank you.
Go ahead, Diane.
Thank you, Madam Speaker. I've brought with me today, I'd like to introduce Robert Garcia, who's one of our legal interns. You probably haven't got it yet, but I know that some of you asked some questions about the recent United States Supreme Court case, Salazar-Carcieri, regarding what tribes could take land into trust. Mr. Garcia read that case, analyzed it, and did a little synopsis, and if you don't have that yet, you will get it. He's a third-year law student at TU, and he's been a big help to us. So this is Robert Garcia.
Would like to say a few words?
From Cherokee County, right?
Yes,
Glad you're coming from TU. Aren't we?
All right. The other individual I have with me is one of our new assistant AGs, Chrissy Ross Nemo. Chrissy is a recent TU graduate, graduated 6th in her class overall. It's a real coup for us to get her here. She is here because she's committed to wanting to serve her people, the Cherokee people, and we are very glad to have her.
Glad to have you.
Where are you from? Where'd you grow up?
I was born in Tahlequah, Hastings. I grew up in Warner. Went to undergrad at MSU here in Tahlequah. So been around around this area. I think I've always lived in Cherokee Nation, even when I was a
Too bad you're not in Mays.
There's a
Glad to
theme-
have you.
There's a theme here, Adair County is losing its grip.
I was just thinking, we gotta get some more Adair County people here. We can't keep our mafia grip.
And I'll tell you how tough Chrissy Ross Nemo is. She used to play softball for, one of her coaches was an individual named Paula Ragsdale, so I'm sure that wasn't a... That probably wasn't very tough. I don't have anything really more to add to that. I'll answer any questions about the report or any other issues that you might have a question for me.
Todd?
Madam Attorney General, you might just go into a little bit about the Salazar case and what effect that you think it may have with the Cherokee Nation or anyone else.
Okay. I don't think it has any direct effect on the nation because it really deals with Indian Reorganization Act tribes or Oklahoma OIWA tribes, of course, which we are not. We have we're here prior to 1934, obviously, and have been in existence since time immemorial. For those tribes who did come into existence after that date, it very much affects their ability to take lands into trust. This case dealt with the Narragansett, and I may be saying that wrong, tribe out of Rhode Island. So it doesn't have any direct effect towards us. Is it good for Indian country overall, or does it show the court swinging towards Indian country? No, it doesn't. For us, however, without going into too much detail here in a public setting, it may be good for us in some of our litigation wherein another tribe who is in that situation is trying to take trust land within our jurisdiction. So our attorneys in Washington have submitted this case as supplemental authority in those cases, and that may actually help us. So, and I think you will be getting that memo, our little synopsis.
Dan, while you're there, if you don't mind, is there anything on GEG?
Not as far as I know. I haven't gotten any updates from the Marshal Service this month. I'm sorry.
Mr. Buzzard?
Diane, give us a brief overview of that Crosby case. How do you feel that's going to turn out? Will you go
The
back-
Cossey?
Yeah, Cossey.
We filed a petition for rehearing this Monday. I believe I sent that over. The Chickasaws also filed an amicus trying to get rehearing. We don't know what the Supreme Court will do. We know that the Choctaws have started the arbitration process and have asked for a stay in their case that's right below ours on the same issue, the DYE case. You know, some of the other tribes are going to go through arbitration. We're in a bit of a different situation because we have this pending lawsuit. I personally think that eventually we'll have to have some sort of legislative fix, and we will try to tailor that as narrowly as possible. But we've been in this, I guess the silver lining of this particular cloud is we've been in contact with more tribal attorneys and tribal folks on this issue than we have in anything during my tenure.
Thank you.
Yes, Mr. Hoskin?
You talk about the fact that the Rhode Island case might help us and not hurt us, but
On this particular issue.
I mean, Congress could fix that case.
They could.
Fix it. And they might fix it. I don't know. I mean, it's
They
just
might.
a few days old. And the lobbying is not your forte, but I mean, are we going to be in a situation where nationally Indian tribes would be wanting that fix, but we're, for our own parochial reasons, might oppose it?
Well, you know, I was thinking about that on my way here. Ms. Hanvey sent me, she's with us today, she sent me a notice. NCAI is actually having a phone conference about this. So obviously Indian country's interested. And it may very well be that where, you know, everybody on the phone call is pounding, what are we going to do? We're not going to take it. And we're going, yeah, well, might be good for us. I don't know. You know, that's something that we really need to discuss. And I don't know. You know, there may be other tribes in the same situation as us that would not necessarily want a legislative fix.
It would be a curious result. Thank
Yes.
you, Madam Speaker.
Any other questions? Thanks, Diane.
Thank you.
Anyone here from the Election Commission? You have to report. You have to report in the book. Is Sharon here, Sharon Swepson, for Tax Commission, or is anyone from Tax Commission? Hello?
I'll make y'all find it.
We impose a fine. And self-governance? Yay! Hi.
My name is Don Vaughn, and it's good to see you all this afternoon. Vicki asked me to attend the meeting on her behalf. You should have a copy of her report in your packet, and I'm sure she'll be glad to follow up with any additional inquiries or whatever. But I wouldn't have anything to add to that, so.
Any questions or comments for Mr. Vaughn? Thank you for coming. Mr. Hummingbird from Gaming Commission. Nice to see you again.
Glad you get to see me.
Me too.
And despite the nasty rumors, the Adair County is alive and well. I believe you also have a copy of my report in your packet. I stand ready to answer any questions you might have.
Questions, comments for Mr. Hummingbird?
One thing, just to reiterate, I think a few of the council members are may be slated to go to the National Tribal Gaming Commissioners Conference in Mohegan Sun in a couple of weeks. Just wanted to let you know that everybody from the council is invited to attend if you wanted to go. It's just not just a couple. So if you feel like getting into knee deep into gaming regulation, you're more than welcome to attend our conference. It's going to be March 9th through the 11th at Mohegan Sun. So.
Are you needing to back up?
I'm up for re-election, so I need all the help I can get.
Mr. So?
Mr. Hummingbird, the last couple of meetings, there were some incidents that had occurred at the casino, and they did voice some concern about the timeline at which you were notified, et cetera, et cetera. Since that time, there's been things that have gone on. Has that process improved, or do you still have some concerns in that area? Or?
I would say I still have some concerns. I think some of the issues that had caused delays in reporting have been addressed, but there have been. I just don't know if that has the philosophy has reached the level that it needs to reach in some areas, because there have been a couple of occasions where we weren't notified of certain activities until it's a much shorter window. Instead of 3 or 4 days, now it's 10 to 12 hours, something along that line. It's usually late at night. But those are times that we still have staff on site, so we should have some type of better communication. And I'm working with the on-site people to make sure that they know where my people are, how to get in touch with them, and if they can't get in touch with them, the underlying rule of thumb, so to speak, is to go up the chain to their supervisor and then up to me if they can't get anybody else.
So there's been some improvement, but
there have been improvements, but we still haven't.
That we've got where we want to be at in both regards to your commission, right?
Right. I think there have been some improvements, but I still think we have a little ways to go to get to the level we want to be.
Any other questions? Thank you, Mr. Hummingbird. Mr. Embry, codification?
Yes, this past week we had another productive meeting of the codification group. Mr. Morton was president with Mr. Garcia and Ms. Nemo. We divided. We got a clear definition of of what titles we were each working on Volume 2. It's coming along really well. It'll be there pretty soon.
Good deal. Does anyone have any questions for Mr. Embry? Yeah, Mr. Baker?
Yes. Say pretty soon, like 3 months, 6 months, 6 years.
No, we wanted to have a draft done by this month, and it didn't get done. I would say we go on a month-to-month basis. We may have something ready by next month. It may be the next, but I mean, I think it's March, April for sure. Okay, but we'll be gunning for next month.
Thank you.
Keep you away, Mr. Baker.
Application so long.
Ms. Glory Ford?
Madam Chairman, I move at this time to amend the agenda to add item number 6. And it would be the resolution accompanying the letter of February 20th, 09 that's been placed in front of you today. It's the resolution regarding the litigation over in the Eastern District.
Moved and seconded. Any discussion on amending? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carried. Under old business, mortgage foreclosures. Anyone here to discuss mortgage foreclosures? Good afternoon, Mr. Morton.
How are you today?
Hi.
Taylor County sends its regards.
Yeah.
This is the month we're transitioning in the record keeping and the more detailed records. I'm now doing the, when we get a case in, I'll send the information, and throughout the case when we get pleadings regarding the case, I will send them over for the report will then be prepared based on that. They're down, my understanding is because there's a moratorium on foreclosures, so our numbers are down as far as how many we're getting in, and I don't know the statistics on how many we have versus the national average, but we'll continue to keep everyone appraised of how many is coming through in the stages of each. Now on the first mortgages, there is some possibility that it would be feasible to buy that property. Now when we have the second mortgage, I'll just reiterate that it probably would cost us too much to buy them, because the first mortgager has to get the value of their loan out of it, plus the added costs that they have to go through the court for the court costs, including appraisal fees and everything else that they have to get out of the property before they let anyone else buy it at a lower rate. So if we don't have the first mortgage, it might not be cost effective to be buying those. I still give the information and all the stuff regarding sales and everything else, but I don't see how we'd ever buy when we have the second mortgage.
Any questions for Mr. Morton? Ms. Laura Jordan?
I like the format.
Is
I
that
like
the new one?
format. It's
Okay.
the one that gives the sheriff's sale information and the appraisal amount.
And that isn't mine. I give them the information, but the format's not mine. Mine was kind of the bare bones and what we put in, but now I supplied the basic information and the format comes through. And it's sent out from our office most of the time the same day or the next day, so they can plug it in. And what I have been doing, if my scanner continues to work properly, is I actually send over the actual document electronically, so there's no lag time and they can actually read the information directly from the documents.
And I noticed that we have a sale coming up. Looks like pretty quick, 225.
It depends on what case. I don't do
Well,
all
that
of
would've
them.
been yesterday.
Yes.
Yesterday. I guess we missed that one.
I think someone was there
Okay.
from our office, but they're not all my cases. It's just when we come in, we report them to the centralized spreadsheet. I may have maybe 5 or 6 of those cases. I'm not the attorney on all of them. I submit my information, and then someone from our office submits all the cases we're handling.
Are you noticing a trend where a lot of the banks holding the first mortgage are letting the sale go at the sheriff's sale instead of buying it back?
I haven't looked recently. I've noticed that I've had a few cases that stop. So obviously they've come to some kind of agreement on a payment plan, or somehow they got alternate financing because we'll be in the middle of one and they'll just dismiss the case.
Well, what we appear to be seeing at our courthouse anyway, the local courthouse, is that we have a lot more of the larger banking institutions that are not buying them back and putting them in their inventory to try to get their whole judgment. They're letting them go for whatever the 2/3 of the appraised value is. So in that instance, it might make sense for us to
Might be
come
able
in
to.
and pick it up.
Yeah. If we start getting them on pennies on the dollar or half price and right then at 2/3, it might be a good idea.
Yes, Mr. Buzzer?
I got a question, and it may not pertain to you, but I know we've had this discussion in some of our subcommittee meetings on housing, but I'm wondering, has there been any, have we purchased any back? Has the administration or the staff have any guidelines of what we'd like to see get done? Have you followed that at all?
Not that I know of. And if we do buy one at a sale, if someone from our office goes, we have to have the authority ahead of time and a letter of credit. And it used to be cash on the barrelhead, but now it's an authorization, and you get the money to them within a very quick period of time to buy it and sell. So if we do start buying them, we do need to coordinate or have someone come with us, and when we attend the sale, buy it, have the money ready, and get that done. Because I'm not authorized to buy anything.
Well, I know this has been in a matter of discussion for the last 3 months, and I'm not so sure there's been any directions on what we want to get done. But I think what we talked about in subcommittee is looking at some of these houses to buy and put them into our system again. But I'm not sure that's getting done. We probably need to have a meeting about housing to see what we're doing on the thing, because I'm not sure we've bought any so far.
Well, I can assist, but
Okay.
my role is basically
I understand.
do this, I go do that. I can't buy or sell anything or commit funds.
We actually, Harley, didn't we set aside money in housing to buy some foreclosed units?
We need to go back. I'm not so sure that we did that, but there was some money available for it. I'm not sure the staff has directions of how we want to proceed on the thing. I haven't heard. Todd, can you answer any of those questions?
Mr.
Yeah, I'm
Inlow?
going to vaguely answer this the
Okay.
best that I can. We do have several folks that are working on this. It's one of the things we are looking at. We've had a team that's been working together, looking at the possibility of using the HOSTA funds to do that, and we've been working on the process. And you're right, we haven't made any purchases as of yet, but we are working on looking at that.
Okay. Well, I just want to make sure that we're moving on this thing, and I know it takes time to get into the
Yeah,
system.
and obviously we want to get some policies and procedures in place and make sure that we're making wise decisions as well.
Okay. Thank you, Madam Chair.
Thank you.
Any other questions? Yes, Mr. Thornton?
Todd, is there any way that we could use the housing authority's proceeds of sale to buy those homes?
That is a possibility. I think that is one of the things that we've been discussing, is possibly using those funds as well.
Does NAHASDA have control over those proceeds of sale?
Not that I'm aware of. I think those are unrestricted funds.
Thank you.
Any other questions?
Would you let me know if they do?
Thanks, Mr. Morton. Second item is constitutional amendments covering term limits. Ms. Callan Watts, can you hear her okay?
Yes, can you hear me?
Yes.
Can you hear me?
Yes, we can.
Okay, so there's 3 items, actually there's A, B, and C under item 2. And before I make a motion on item 2A, just a reminder that all 3 items do not call for a special election. They would be items that the people would vote on during the regular 2011 election. So I make a motion to approve item 2A, which allows at-large voters to have another opportunity to register in their traditional home district.
A motion, do I have a second?
Second.
Moved in second, now discussion. Mr. Baker?
Yeah, I'm going to oppose this again, mainly because it's so confusing. The Constitution said that they would have one bite at the apple. This is given a second bite. Now it is more confusing than ever because they have already voted in a cycle at large. So now they're acclimated to, I was disappointed. I didn't fill out the papers in time. Now I'm over here and I've already gone through the system once. I know how to do it. I have 2 competent council people instead of 1. All these reasons as to why, taking another bite at the apple is going to be more confusing yet than it ever was, and it's going to keep the voters list and the election commission and everybody in flux till 2018 or 20. And at least right now, everybody knows what they do, how they do it, and have experienced it. And if we do this, if it passes a vote of the people, then it's going to keep everybody in flux for a whole, another 4 years after that. And I think what's done's been done, and I think it was thought out clearly at the Constitutional Convention. And I think those that really wanted to did. A few missed it, but hey, what have they been harmed? They still get to vote for the chief, they still get to vote for the deputy chief, and they get to vote for 2 council people instead of 1. So I'm going to oppose this just to keep the confusion from coming back in, because if we do it, folks, and they pass it, we're going to have the same complaint 6 years from now that, oh, I didn't get my paperwork in time, I want another bite at the apple. Thank you.
Mr. Baker?
Yes, Mr. Hembry.
Yes, sir.
In the last whereas, the 5th line from the bottom, where it says all citizens age 25 or older residing outside the boundaries, not registered to vote at the time of the first election, may only register to vote at large. That's in direct violation of the first sentence of the whereas, I believe.
Okay, the 5th sentence or the 5th sentence down, or from the bottom. All citizens aged 25 or older residing outside the boundaries, not registered to vote at the time of the first election, to fill at-large council seats, they only register to vote at large. Okay, and you're saying, and that was the original language of the Constitution from our deal. And it says, and then at the first sentence it says, all registered voters residing outside of the boundaries of the Cherokee Nation may, at the time of the 2013 election to fill at-large council seats, choose to be registered to vote in a district within the boundaries of the Cherokee Nation. Okay. I see your point. How would you propose to fix it?
Strike the all citizens age 25, that last sentence, the all.
Well, wasn't that part of the? I mean, we had a major debate on that in the Constitution. I mean, it's my understanding that the way I structured the amendment was to give everybody one more first-time shot.
But this sentence prevents that, because we've already had the first election to fill in that large council seat.
Jack, may I interrupt just a moment? I think Mr. Hoskins may have a point.
Okay.
Would putting except as set forth herein, comma, solve that problem? All citizens, except as set forth herein, all citizens age 25. I don't want to overcomplicate it, but.
Mr. Baker?
Well, we already have the above about addressing the citizens under the age of 25 as opposed to those over.
Mm-hmm.
So I would think you could just strike that.
I'm fine with it. I argued against that provision in the Constitution Commission anyway.
Go ahead, Mr. Hoskins.
We're not striking what's already in the Constitution about folks under the age of 25 continue to get that opportunity.
Right.
That'll be preserved.
Yes.
So
I would agree. Yeah, that's right. It's stated notwithstanding the above citizens age. Yeah, you're right. We could strike that. I would recommend that. Strike that.
Mr. Baker?
So please clarify.
I ask for a friendly amendment to strike that sentence.
Cutting in and out, so strike which sentence?
Yeah. All citizens age 25 or older residing outside the boundaries, not registered to vote at the time of the first election to fill at large council seats, may only register to vote at large.
And you want to strike that sentence?
Yes, because it's in direct violation of the first sentence in that whereas.
Okay. I accept. I don't know who my second was.
I will. Okay.
Any other comments, discussion? We have a motion and a second. This is...
Madam Chair,
Yes.
I'd like to comment just for...
Oh, go right ahead.
You know, we have a brand new constitution that was just voted in by the people, and we're actually operating under it right now for the first time. And, main reason I oppose this is why do we want to change a brand new constitution that the people just voted in? They just voted this part. They said you have one trip to do this, one time to do this. We went through that process a little less than 2 years ago. If we do this, and they voted in to change it in 2011, the Election Commission has less than 2 years to implement it. And do you not think that's going to cause more problems than we're trying to fix? I agree with Mr. Bill John Baker that they've done it once already. They have 2 very able-bodied representatives that represent them. I do not see why we need to be making this change or even putting this on the next election. And I'm going to oppose it for those reasons.
Dr. Cobb?
I would agree with Councilor Jordan in that they just voted this in, but I do think one of my issues is that, and always has been, at the risk of offending the Election Commission, I think the citizens have a reasonable expectation that what they voted in, their one-time shot, the paperwork associated with that would be delivered in a timely manner, and it was not. I had people 6 months before that election saying, when am I going to get my paperwork? I want to vote in this district. And about 6 weeks before the election, we started getting paperwork. And one of my issues with this whole thing, I think a citizen, when they vote something in and it's implemented and there's paperwork required from that decision, I think those citizens have a reasonable expectation of a timely manner delivery of those documents, and it was not done. And that's exactly why I'm going to support this. Thank you.
Ms. Fulbright?
Well, thank you. I'm going to support it because, for the exact same reason that he said, because so many of the people that live across the line over in Arkansas, some of them elderly, some of them maybe they had moved, I don't know, but when it come time to vote, they had never received anything that they knew of, and they went right over to Muldrow to vote, and some of them filled out a protest ballot, but it was all thrown out. I mean, their vote didn't count. And I had a 92-year-old that had been voting there all of his life, and he said he hadn't moved in 40-something years, and then he gets this deal that he can't vote over at Muldrow, and he wasn't notified in the mail. I don't know, that's what he told me. And as far as voting in the Constitution, we just voted it in, that's true, but it was all or nothing. You take it the way it is. There was lots of parts of it I didn't agree with, but I voted for it. So that maybe we could change it and make it better. That's why I'm for this. Thank you.
Anyone else? Mr. Thornton?
I probably looked at this a little different. I think this was voted on through the new Constitution, but I also think that we have 2 at-large councilors. I think we have people at large, and the people at large should vote at large. That's just the way I feel. And people in my district should be able to vote in my district. So I'm going to have to be against this. Thank you.
Anyone else? Okay, we have a motion and a second. It is a resolution. All in favor, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call.
Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Fraley,
No.
Janelle Fulbright,
Yes.
Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Gloria Jordan,
No.
Curtis Snell,
No.
Chris Tuck,
Yes.
David Thornton,
No.
Kara Cowan Watts,
Yes.
Buell Anglin,
Yes.
Bill John Baker,
No.
Jack Baker,
No.
Harley Buzzard,
No.
Julia Coates,
Yes.
Bradley Cobb.
Yes.
7 yes and 10 no.
7 yes, 10 no, motion fails. Okay, Kara, the next item is item 2B.
Thank you, Madam Speaker. So this is a separate ballot issue again for the 2011 election, dealing with the chief and deputy chief to eliminate term limit executive branch. I move to approve.
Motion to approve. Do I have a second?
Second.
Moved in second. Discussion. Mr. Hoskin?
Thank you, Madam Speaker. It concerns me that there might potentially be a special election where one may not be warranted. Special elections are expensive propositions, and I mean, there's times when you want a special election when there's a emergency type situation, but I'm not sure that people think term limits recension is an emergency. I've said before, I'm against term limits. I'll say it every time I'm asked. I don't know I can support it with the prospect that we might go to a special election on this issue, so I'm curious as to why we have it looks like we have a provision here that would allow it, but I'm curious as to why, if the drafter knows or if the sponsor knows.
Ms. Chambry?
Well, the intention is not to have a special election. The be resolved clause, the very last be resolved clause says, be it further resolved by the Council of the Cherokee Nation that this amendment shall be put to a vote of the people during the 2011 general election of the Cherokee Nation. So with this, it's the intention that, and in the wording, that it be on the general election.
But don't we have in the fourth whereas language that contemplates we might come back and direct it to a special election? Or do I have an earlier draft?
What that fourth whereas clause is just quoting what the Constitution states. Under Article 15, Section 2 of the Constitution, there are two ways to call an amendment to the Constitution. One is by resolution of the council, and the council can either set that at for a general or special election. That's Article 15. That's just quoting Article 15, Section 2. But further in this resolution, you set the election date for the general election of 2011.
Thank you.
Mr. Wade Jordan?
But could, theoretically, if 12 people vote for this from the council, theoretically, could a special election be called?
Well, you never lose your right to call a special election. But basically, if 12 people if you were to pass this resolution and then pass another one to call a special election, well, there would be people going against their word, and theoretically you're correct, but you would have to be diametrically opposed of what you just passed in this resolution, because this resolution clearly states that is to be in the general election of 2011.
Well, we won't go there that anybody's ever changed their mind on this council.
Okay.
But what you're saying is then, if 12 people vote on this, it is possible that it could be put to a special election that could cost us $250,000.
Well, yeah, I'll just state what I stated. I mean, this resolution calls for a general election. 12 people at any time, on any issue, can call for a special election. That you don't undo that constitutional right.
And again, I have the same opposition to this one that I had to the other one. The people have voted on this, and they voted for term limits. And this is really the first council that is even acting under the new Constitution. So why are we going back now and changing it or attempting to change it? Let's leave it alone and let it operate for a while.
Dr. Cole?
I'm going to be supporting this, but probably not for the reasons that you may initially think. If Councilor Hoskin and I were in the same room, he would probably tell you how much he opposes term limits, and I would probably tell you the opposite. I am a firm believer in a little revolution is good for the soul every once in a while. I think term limits are a good thing. But by that same token, I do think this is much bigger than obviously this council, and this resolution is for an amendment to the Constitution. I do think the people have the right to vote on this. I think the people have the right to say what they think about it. And I have heard out in the communities enough discussion from different people that I think there is some differences of opinion on this. I know that we're operating under a constitution that has been voted on by the people, but I'm getting different views in the community. So I am all for getting something to a ballot and letting the people decide. I am in favor of term limits, but this is a much bigger issue than I am. So that's all I have to say. Thank you.
Ms. Fulbright?
Thank you.
Go ahead now. Sorry.
Well, I'm supporting this, and unlike Dr. Cobb, I am always against term limits anytime, any place, because all elected officials are term limited anytime they're up for an election. It's called voting. We can vote them out at any time. And I am against term limits, and this is the way it was written. We accepted it, but I do not agree with it, and that's why I think people can limit the term of anyone if they just get out and vote. And history will prove that. You'll hear people argue and say, oh, so-and-so, he's been in there 20 years. We need to get him out of there. Well, it's possible. Everybody just go vote however they choose, and I'm against term limits. Thank you.
Thank you. Any other questions, comments?
I do, Madam Speaker.
Oh, go ahead, Kara.
Thank you. I appreciate that we just voted on and passed that entire Constitution, but I recall at the time that it was an all or nothing, which I adamantly opposed, and even though I valued several new aspects or amended aspects of the new Constitution as positive moves forward for the tribe, I absolutely disagreed with different aspects of the Constitution that were passed in the all or nothing package. With that said, many of my community members also have mixed feelings about this amendment or any of the amendments, but they all agree that it is their absolute right to vote on these in an individual manner, and that there wasn't enough dialogue on these particular issues in the Constitution, and that they want an opportunity to vote solely on these individual issues, and that's why I brought them forward. So I think it's important that we put this back in the hands of the people, and that it's a critical issue for the long-term health and vitality of our tribal community, and that we operate differently, and that many of the national committees and the different things require, like as I've served on those committees, I've watched elected officials have come and go for various reasons, and it doesn't help Indian country. So if the people choose to leave somebody in there to develop and grow with the tribe, I think it's absolutely their right as a voter, and I'm going to vote to support it. Thank you.
Ms. Fishing Hawk and then Mr. Soap.
I'm opposed to this because I believe if people feel strongly about something, then they can get a petition and they can change the law. If they feel that strongly about something, that's all I have to say.
Mr. Soap?
Todd, could you elaborate on the, in section 1, the second to the last sentence? It makes references back to the election cycle in year 2003 and then every 4 years after that. But then it talks about the principal chief shall be elected by a majority of the votes. Can you just kind of detail that for me as what the majority is and how that's interpreted?
Well, majority is that you must receive of the votes cast. You must receive 50% plus one. Okay, that's why it's not a plurality of the vote.
That's pretty well just the standard understanding, and
there's only one other state in the union that doesn't do it that way, and that's Louisiana.
Right. But I'm just saying that they don't say majority. 42% is how they interpret the majority, and that's that stands and
Yeah.
is understood.
50 plus 1.
Okay, thank you.
Any other questions? Okay, have a motion and a second. All in favor of approving this signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call.
China Gloria Jordan,
No.
Curtis Snell,
No.
Chris Soap,
Yes.
David Thornton,
Yes.
Kara Cowan Watts,
Yes.
Bill Anglin,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Harley Buzzard,
Yes.
Julia Coates, Bradley Cobb,
Yes.
Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Braley,
Yes.
Janelle Fulbright, yes, Don Garvin,
Yes.
Chuck Hoskin Jr.
No.
We have 11 yes and 6 no.
11 yes, 6 no, motion carries. Okay, item number 3A, or no, 2C. Kara, did you want to?
Yes, Madam Speaker, this is a similar vote of the people on the 2011 ballot. It would not be a special election, and it would be to eliminate term limits for the legislative branch. And I make a motion to approve.
Second.
Motion and a second, discussion. Cobb?
Just to reiterate, again, I am a fan of term limits. I am not I have a, what is that you said, I'm diametrically opposed to career politicians. I think a little revolution is good for the soul occasionally. I did want to comment, and I do agree with Councilor Fulbright, but I think if you Google percentages of incumbent victories in U.S. national elections, I think you'd be shocked. I think you'd be shocked. I'm not sure what you have to do as an incumbent to make enough people mad not to get elected, but the ability of an incumbent has a built-in help mechanism there in elections, and I do agree. Those that say, well, we do have term limits, you're elected every 2-4 years, whatever the case is, maybe. I just really think an incumbent has a built-in advantage, and I am in favor of term limits, but by the same token, and I will reiterate, this is a much bigger issue than I am. I do agree that the people need a voice on this. I understand we're operating under a new constitution, but I have heard enough differences of opinion in the communities in my district on this issue that I think this needs to go to a vote of the people, and I will be supporting it.
You might
Thank
ask Mr. Steinar.
Good point.
Todd,
But I can come up with
I'm kind of confused here on this issue. Both of these amendments. I think this is up in front of the court right now. If they decide that some of us, or chief or deputy chief, is on their second term limit and they can't run again, then that means it's an oncoming election in 2011, that it doesn't make any difference whether the people vote on this or not. You're still not going to be able to run if they make that decision, right?
Yeah, there is a case pending to which the council is attempting to be a party. They haven't ruled on that yet, but I'm sure that they will allow us. That the whether you all are on your second or first or second term under the 1999 Constitution. So in that obviously will be decided before the 2011 election. Yeah, hope so. So yeah, you're right. That's going to be determined. But if I may just interject one thing, with your previous vote, the die has kind of been cast here, because you definitely don't want to put the legislative branch at a disadvantage of being term limited if you're going to give the opportunity to the executive branch not to be term limited. Actually, in the federal system, it's just opposite. the executive branch is term limited because of the greater power or the greater exercise of power the executive branch can wield, and the legislative branch is not term limited. But so I'll just point that out with this upcoming vote, is that you definitely, as the attorney for the legislative branch, I would hate to see the legislative branch more hamstrung than the executive branch.
Any other questions, comments? Yes, before Jordan.
I actually think Todd makes an excellent point. If we've already voted in the other one, I guess we need to vote this one in so that they're companions. And if one goes on the ballot, both need to go on the ballot.
Any other questions, comments?
Madam Speaker?
Yes, Kara?
Thank you. I think, me personally, when I've talked to my constituents, part of the power of this body, or at least when I felt like I presented it, was I presented independent of myself and my seat. I'm presenting it into knowing that the court could rule that I have no power to run, even though the people in the 2011 election could vote to remove term limits. And so it's not, personally, it is something that I believe is really for the Cherokee people to vote on, and it's absolutely their right, and doesn't have to do with our personal interests as council people as we're seated today. Thank you.
Thank you, Kara. Okay, all in favor signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Motion carried, one opposed. Okay, item 3 is the Cherokee Nation travel local mileage policy. This was tabled from last month. I don't remember why.
Madam Chairman, it was tabled for this body to consider a legislative act concerning 2399. Now we've passed an act, or an act has been placed in your packet. What I would ask is that this travel policy be tabled to next month, and that you take action on whatever you're going to take action on in the following business item, and then depending on that, consider your policy next month.
Okay, thank you.
Motion to table.
Second.
All in favor to table signify by saying aye.
Aye.
All opposed, same sign. Table to next month. Now, under new business is an act amending LA 2399 travel reimbursement. Mr. Anglin. Oh, Bill, before you start, there's 3 different pieces of legislation here. Todd?
Madam Chairman, if I might, based on conversations that I've had with the sponsors of the act, before you is what I'll call Travel Act number 1, which called Travel Act number 1's in the book. Okay. Travel Act number 2 is a slight modification of that, changing the amounts from 1,200 to 700. There's a third act which calls for the repeal of Legislative Act 2399 and and the substantive provisions will state that the tribal council will determine its mileage and travel expenses through its own policies and procedures. If it's the will of the body or the will of the sponsor at this time, you would want to move to substitute one of those acts for the act that's in the book, and then consider that one.
Mr. Anglin?
Yeah, thank you, Madam Speaker. Yes, I'd like to substitute what I'm calling number 3, the final act. Everybody should have that. It won't have any figures at all in it. It's just a policy change. It's to develop internal policy and procedure for reimbursement of mileage and travel expenses concerning any meetings of the tribal council. That's an official tribal business. I would put this act in the form of a motion, and it'd be the third and final.
Second. Moved in second. Any discussion? Mr. Baker?
Yeah, Todd.
Yes, sir.
Do you have that 2399 in front of you?
Yes, I do.
Do you mind reading it? Because I think there's a place in there that it was only for that elected term, And then it says that the council will go by their policies from that part forward. But let's read it and make sure I'm not a lawyer in this room. We've got plenty.
All right. 2399, the substantive provision. In addition to the compensation authorized by Section 21 of this title, any council member attending regular council sessions or official tribal council meetings called by the council or administration shall receive reimbursement for actual expenses for mileage. Proper receipt must be documented and submitted for reimbursement. The effective date of such compensation shall commence on November 15th, 1999 and continue thereafter for the duration of the term of elected office unless amended. Council members shall be subject to policy procedures as adopted by the tribal council from time to time and shall not be subject to human resource policies adopted by the executive branch of the Cherokee Nation. You can a reasonable person could interpret that to be a sunset clause. I personally do not. I believe that there was no limitation as to that particular term of office. It states what two ways you can receive reimbursement for, and it is my opinion that, and plus, this is these procedures were strictly followed from 1999 till 2007, and so therefore I think that lends credence to the fact that there was no sunset clause on it. Be that as it may, I believe that the most prudent course of action for this council is to repeal Legislative Act 2399, and if it is the wish that you set your policies and procedures yourself, which is totally within your constitutional right to do under Section 4, distribution of powers, and Section 6, Article 6, Section 2 of the Constitution that says that you have the right to set your own rules and procedures, I believe that's the more prudent course to take.
Any other questions?
I had one. Go back through that, what that said about not subject to HR department. Read that again.
Council members shall be subject to policies and procedures as adopted by the tribal council from time to time and shall not be subject to human resource policies adopted by the executive branch of the Cherokee Nation. So therefore, HR cannot come in and say you violated the policy, you're fired, or that is a ground for impeachment.
Thank you. That's what I wanted to hear.
Callie, did you have a comment?
My only comment is related to half of council's funding is from indirect costs. So we should probably put some reference in there that it's subject to any, federal guidelines regarding travel and that sort of reimbursement. Then the other thing was whether it's an accountable or a non-accountable plan, that makes the distinction whether it's taxable income to you or not.
Douglas?
I just have a comment.
Madam Speaker?
Just a moment. Doug has the floor, Kara.
I'd yield to the councilor.
A question for Callie on what she just stated.
Yes.
Okay, go ahead, Kara.
Okay. So the question is, how is chief and deputy chiefs travel authorized? Do they have similar language then, or do they require? I mean, I understand we're doing this to make our procedures clear and to clarify past paperwork, but is that the same then for chief and deputy chief?
The chief and deputy chief follow our travel policies, which conform to A87 requirements as far as documentation. What is under discussion, if I'm understanding correctly, is basically a monthly stipend for council members rather than mileage reports, and that is certainly allowable as long as it's reasonable and necessary.
My comment was that I was, we lose somebody?
Go ahead, Doug.
Okay. Addressing a single line item within our budget, I would disagree with Callie in the need to actually put language into this act or remove language from the act if you're going to repeal a previous act that addresses the 87 implications. This is merely one line item within a budget, and as long as it meets the 87 requirements as she stated as being reasonable and necessary, then I don't understand why we would need to put language in a repealing act to address that. Now, there's obvious IRS stipulations that's going to come into play when you start talking about an allowance that you may reference as at least letting a reader know that we will still follow the Internal Revenue Code as it's applied here. But I'm not sure I understand why we would need to address A87.
I call for the question.
Question's been called. All in favor, signify by saying aye.
Aye.
All opposed?
Aye.
One Did you oppose?
Aye.
No, you opposed. Next item is number 2, the Declaratory Judgment Act of 2009. During the judicial conference, the justices asked that we establish authority for them to exercise declaratory judgments, and that's the purpose of this act. And Mr. Henry, you want to continue on?
Yes, Madam Chairman. What you stated is correct, that this was an item that the justices wished for the council to consider. After that conference drafted this, I have sent it to the Attorney General's office for their input. They had a couple of kind of housekeeping measures that I would agree with, and that I want to announce in committee here so that we can make those changes. The first change is in the substantive provision, section A, 5, 6, the 6th line down where it says liability or non-liability. I didn't put a hyphen in there between non and liability, so added a hyphen in there. And then the next line down, I misspelled torches, and so we would torches is TORTIOUS. And then on the second page of the Act, Part C, item B under subsection C, at the end of the sentence, change however to provided. And then at the end of section B, delete the last sentence because we do not have a Department of Corrections in the Cherokee Nation. And with those changes, I would, those minor changes, the Act, everyone agrees with it.
I move that it be approved.
I have a motion to approve. Do I have a second? Do I have a second? Any further discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carried.
That'd be by acclamation.
Acclamation, thank you. Item 3 is the Territorial Prompt Payment Act of 2009. I'm sure that most of us are aware that a lot of our contractors haven't been paid in a timely manner in certain situations. Hence the prompt payment clause to be acted on today. However, the principal chief called and asked that we table this because he is contacting contractors and subcontractors to try to find out where the problem lies. Is it systemic, or what is the problem? And so I'm putting that before you. If you want to table, that's fine, or we can act on it, that's fine, but he did make that request. And I do know he talked to a contractor from Locust Grove, and I think he's talked to some, Harley, didn't you submit some names to him? Part of the problem that has come to note is that the retainage fee, a lot of them haven't been paid for the retainer that they put forth. But in Locust Grove, the gentleman that's a subcontractor for C&I, he hasn't been paid for the contract, which is 60 to 90 days. Mr. Garvin, then Mr. Hoskin, then Mr. Baker.
Madam Speaker, I make a motion we table this till next month.
Second.
Motion to table. All in favor signify by saying aye.
Aye.
All opposed, same sign.
Aye.
This table.
Aye.
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 I just,
Is that all in a to table or they opposed?
Opposed, let's have a roll call. Tell
Roll
everyone
call.
voted
I'd ask for roll call.
Oh, okay, I'm sorry, I didn't hear you. Yes, it's the table.
Yeah, I think it needs to be.
Jack Baker,
Yes.
Harley Buzzard,
No.
Julia Coates,
Yes.
Bradley Cobb,
Yes.
Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Braley,
Yes.
Janelle Fulbright,
Yes.
Don Garvin,
Yes.
Chuck Hoskin Jr.,
No.
Tina Gloria Jordan,
No.
Curtis Snell,
No.
Chris Soap,
Yes.
David Thornton,
No.
Kara Cowan Watts,
No.
Buell Anklin,
Yes.
Bill John Baker.
no.
Madam Speaker, would I be out of order to ask you a question about the chief's position on this from what your conversation was? And there was one
He
thing I
didn't
was
state a
curious.
position.
He didn't state a position.
No, he did not.
We have 8 to table and I'm not.
And not to
8 yes, 9 no.
Okay, motion fails, so we will act on this one. Miss Callie? Miss Callie.
Thank you, Madam Speaker. I would just like to voice some concerns with the implementation of this act as it is written. I was a little confused on the payments section where it talks about interest penalties. It says payment office will pay an interest penalty automatically without request from contractors when all conditions are met, and then it lists some conditions which are relatively difficult to pin down, such as a disagreement or a settlement action. Then it talks about a penalty on top of a penalty. I can tell you from the payment side, this is going to be difficult to implement and track. The other major concern I have is if we're using federal dollars in any of these contracts, which of course we do with tarot vendors, we are not allowed to pay penalties and late fees using our federal dollars. They're disallowed. So any of this would have to come from our gen fund coffers. And I personally was not aware that that was a problem on the nation side as far as paying our bills. Personally, I would prefer that we visit with contractors, look at our processes, see what the problems are, and fix those problems rather than legislating a mandatory interest charge. Thank you.
Thank you, Callie. Mr. Hoskins, Mr. Thornton.
I guess this question could be for Callie, but do we normally have a problem paying within 7 days or even 10 days that would trigger the interest? I know that's been a problem lately, but generally, would you think the system in place could comply with that?
Here's how our system works, and I'm talking about accounts payable in my group. Generally, the invoices are signed off on by the program who is contracted for the work. They signed off that they've received the goods or services. Then they're sent to our building. If they get into our office by Friday at 1 o'clock, I think, the contractor normally has a check the next Friday, either Wednesday or Friday of the following week. So about a 14-day cycle there. We process about 10,000 invoices a month in our office with 7 people in our accounts payable department. So they do a really good job. But if an invoice gets to the wrong department or the paperwork doesn't make it in, there could be a slight delay. I would say that there's not a big problem with paying within 30 days, which is what most of our vendor terms are.
Mr. Thornton?
Madam Chair, I call for the question.
Question's been called. All in favor signify by saying, oh, this is an act, isn't it? Roll call.
Christo,
No.
David Thornton,
Yes.
Kara Cowan Watts,
Yes.
Bill England,
No.
Bill John Baker,
Yeah.
Jack Baker,
No.
Harley Buzzard,
Yes.
Julia Coates,
No.
Bradley Cobb,
No.
Joe Crittenden,
Yes.
Jody Fishinghop,
Yes.
Meredith Fraley,
Yes.
Janelle Fulbright,
I abstain.
Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Hannah Gloria Jordan,
Yes.
Curtis Snell.
Yes.
We have 10 yes, 6 no, and 1 abstention.
10 yes, 6 no, and 1 abstention. Motion carries. Todd?
Well, given some concerns that were raised here today, we will, like we do on any other act, work with the administration or anyone else, try to see if those concerns can be settled by amendment, possibly on the floor. But this way, the act goes forward to full council, and we can take action on it there.
Item 4 is a resolution setting dates for committee meetings and council meetings. Dr. Cobb.
This resolution was born out of some discussions with counselors over the past year with some level of frustration with some of the downtime on some of our council days. And I asked Todd to draft something up for me, and I'll be the first to admit that this is fluid, this is flexible on my part. But one of the frustrations was, especially on Tuesday, when we have this huge gap. And I'm just one of these people that when I'm here, I want to, be working and doing something. But basically, what this resolution is about is that what this resolution would do is on council day on Mondays. And you can see the schedule there. It would have community service at 10, education and culture at 11, health at 1, and resource at 3. And it would move committees other than E&F and rules to one day. This is what this particular resolution says, and I would move for its approval.
Second.
Moved in second. Discussion. Yes, Gloria Jordan.
Would you possibly accept a friendly amendment to move Community Service Committee to an earlier time, say, Harley 9:30?
I'm pretty flexible on anything with my committee. It doesn't matter,
It would give us a little more time to visit on those issues pertaining to that committee.
It suits me just fine. Whatever this committee wants is fine with me. I'm pretty flexible on my times.
So you're asking that on the friendly amendment that you're saying move community service early, but leave everything else the way it is on the Monday. But you're moving it. You're saying. For right now, I'm not going to accept that amendment. I'd like to see some more discussion on this, if we could.
Mr. Baker.
Yes. I know that Julia has a problem. She flies in on Monday, so I would suggest that we move education to, say, 4 o'clock on Monday afternoon.
And so we're just go ahead. I'm listening.
Actually, what I would really prefer to do is having resource at 3, education at 4, and then community service at 9 on Tuesday, and health at 10. And then if there were any questions that were not resolved on either the resource or education committee, those committees could be recessed until 11 o'clock or so on Tuesday.
So your friendly amendment would, on Monday, would start at what time then?
At 3.
And then what about Tuesday morning?
At 9.
Well, that's one of the reasons I wanted to hear some discussion, because I knew with Julia's schedule and being where she was, I didn't want to, obviously, that's, I would accept that, actually. I would accept that as a friendly amendment.
Okay, so Brad, tell us what you're accepting.
Hey, we can't hear like the last 2 minutes of stuff blinked out.
Yeah,
we're getting a lot of static. We can't hear anything, and it's.
What's your telephone?
Yeah, I think it's your phone, isn't it, Kara? Huh?
Kara.
Kara?
Now I can hear you for the moment.
Can you move your cell phone away from your computer?
Hello?
Kara,
Hello?
move your cell phone away from the computer, please. Way to go.
Hey, I asked if Julia's with us too, because I think she had a question.
Julia, did you have a question?
Well, I mean, I'm on all of these committees on Monday, and the fact of changing the education around until 4 or whatever is not. I mean, it would. I don't have a problem. I usually come in the day before. It's just that occasionally I've got a class on a weekend someplace that allows me, or that means that I can't fly in until Monday. And just on those occasions, it would mean that I would basically miss all of these committee meetings except perhaps education if it was scheduled later. So for me, it really doesn't make any difference in terms of what time education is at. If that makes things any easier.
Mr. Baker?
Yeah, always in the past, the chairmans of the committees, they've obviously taken input from the members, but they've always set their times to their committees. I mean, I don't know why we're doing it in toto and making it rigid as to, this is just the time, because from time to time we have meetings where we go to Bull Hollow, or we have meetings that go someplace else, and I just don't know that I wouldn't be for letting the chairman kind of work it out, as long as they keep it on that Monday and Tuesday. And I mean, I don't care if everybody gets out at noon on Tuesday if we don't have pressing business. But I just don't know that we need to take a whole lot of time reinventing the wheel when it's already in the council procedures that the chairman set the committee time.
Julia, did you want to say something?
Yes. As I look at this, I mean, if the problem is really the lag time between the 11 o'clock health committee meeting and the 1 o'clock education committee meeting, or I'm sorry, the 10 o'clock health committee and the 1 o'clock education committee on Tuesday, what I would maybe suggest as an alternative is if we begin community services at 10 on Tuesday. If we're going to start it at 10 on Monday, then what would be the problem with doing it at 10 on Tuesday? And that would eliminate the long lag period that we have between 11 and 1. And we could still have the flexibility that Councilman Baker has just spoken to extend meetings a little bit longer if need be. And so forth. So I would just offer that suggestion as well.
Dr. Cobb, may I ask a question? What's the objective of changing this from the way it is now? To get it all in one day?
Originally,
to save expense, or what?
I think originally that the very first thing that originally brought this up is, I know on Tuesdays there's a big gap, and between, the committee's escaping me now, but sometimes we're finished at 11 and we don't start back until, significantly later. And there was, originally the discussion was because there was such a gap there. And I'm not opposed to, and I believe, if I'm not mistaken, my parliamentary procedures are not up to your standards, but I think you had given a friendly amendment. And I think originally, to solve that problem, I was in favor of this resolution to do everything on one day. A byproduct of that, in answer to your question, was yes, it would save some hotel fees and some of that. I think that in discussion with some of the counselors after the resolution was put forth, everything turned back to the original long gap on Tuesday. So while, and I hope I'm answering your question, while a byproduct of my original resolution was saving some money on the hotel expenses, it seems to me that the most pressing concern of some of the counselors that I talked to was the large gap that we have on Tuesday. We're not really accomplishing anything except a really long lunch. And so, but I do have a question. I think there is a secondary friendly amendment here that we never really addressed, or
I don't know what it was.
Well, if I'm not mistaken, was your, and correct me if I'm wrong, what may I, what was to have 2 of the committee meetings on Monday afternoon and move community service and health or leave them, I should say, on Tuesday morning at 9 and 10, and that would so essentially you'd be coming in on a Monday afternoon and then stay all day through committee, through legislative conference and all that, and then on Tuesday morning be finished after health committee at 10, I believe, that's what the amendment is. And if I'm mistaken, please correct me.
Bill John?
I'm sure. I'm really not opposed to shuffling and changing and trying to accommodate everybody. However, I'm gonna move to table this in order to give the chairman an opportunity to come up with a workable schedule, and if they announce it and it works, then we don't need to legislate it, and that's a form of motion.
Motion and second to table. All in favor signify by saying aye.
Aye.
All opposed, same sign. No. Roll call. Yes is the table.
Bill England?
No.
Bill John Baker?
Yes.
Jack Baker?
Yes.
Harley Buzzard?
Yes.
Julia Coates?
Yes.
Bradley Cobb?
No.
Joe Crittenden?
Yes.
Jody Fishinghoff?
Yes.
Meredith Fraley?
Table, no.
Janelle Fulbright?
No.
Don Garvin?
No.
Chuck Hoskin Jr.?
Yes.
Tina Glory Jordan?
Point of clarification, yes, is we're gonna go ahead and we're gonna table. No.
Curtis Snell?
Yes.
Chris Soap?
Yes.
David Thornton?
Yes.
Kara Callan Watts?
Yes.
I didn't change mine, Shirley, I was confused. I don't want to table it.
So you want to vote no?
Right.
We have 10 yay.
10 to table and 7 no table. So we'll table it to next month, Dr. Cobb. Okay, item 5 is a resolution confirming David Blue to the CNB Business Board. Who's sponsoring that?
Move to approve.
Second.
Moved in second. All in favor?
Oh.
Oh, sorry. We got it.
And I will second.
Okay, move to table. All in favor signify by saying aye.
Aye.
All opposed, same sign.
No.
And that was the table of this resolution? Okay.
And no.
And I did too. No. Item 6 is the one that we amended to include. It's a resolution ratifying litigation in the U.S. in the Northern District.
Second.
Moved and seconded. Any discussion?
What does this do?
Who's here to discuss? Doctor.
Not very much.
Yours, Doctor.
What does this do?
This, according to, and I can't remember the legislative act, we have a law that says that we have
Be quiet just a moment.
It is the law of the Cherokee Nation that litigation can be filed on behalf of the Cherokee Nation where our sovereignty or substantial assets of the nation are at stake. In order for, but after that is done, prior to or after that is done at the next meeting, the administration must get consent of the tribal council to ratify that case. If the council does not ratify that case, for instance, in this instance, we would be forced to withdraw or dismiss that case.
Is this a righteous one?
Huh? Pardon me?
Is this a righteous one?
Yes. I mean, this puts the question of the freedmen squarely on the merits in the Northern District. I mean, it's better. It's more well suited for a decision on the merits than the Washington D.C. case, in my opinion.
Further discussion? Yes, Ms. Gloria Jordan.
Does this mean that Diane will take more participation in the local case?
Yes, the local case, the attorneys of record or the Hall Estelle firm and Diane Hammonds as Attorney General of the Cherokee Nation. It is, I know, contemplated that her office will be more hands-on in this lawsuit.
So by being local, it will save us money, you believe?
Well, in that Hall Estelle probably, well, I know, charges less than Orrick, but it will. Well, it's going to cost us more money now that we have 2 lawsuits going. Well, actually 3 lawsuits going. We have the Freedmen litigation in tribal court. We have the Freedmen litigation that was, the Maryland Van lawsuit in Washington D.C. court, and now we have started the Cherokee Nation versus Nash and a few other freedmen in the Northern District Court. The idea of filing the Northern District Court case is to get the case squarely on the merits and a bright line decision whether the freedmen and the freedmen descendants are entitled to citizenship in the Cherokee Nation. And now, will it save us money? Well, no, not really, because we're starting a 3rd lawsuit. But is it better suited to get a decision on the merits? Yes, it is.
Any other questions? All in favor signify by saying aye. Aye. All opposed, same sign. Motion carries. Okay, any announcements?
Starts 10 minutes after our adjournment here.
What?
Unanimous starts 10 minutes after our adjournment.
Oh, okay. Excuse me, I'd entertain a motion to adjourn.
So moved. Second.
All in favor signify by saying aye. All opposed? Same.